Good day, and you are watching Strictly Legal on WESN Content Capital. I am your host, Rondell, attorney at law. Once again, we are happy to have you here watching us and exploring the law and you. Of course, this is part 2 of our series of should the CCJ be adopted as the Commonwealth Caribbean Final Appellate Court. And last week, we were discussing this topic with Professor Leslie Thomas, Queen's Counsel in the United Kingdom, and he's here with us again at part 2 of this series. Of course, last week we were exploring the historical context of the Privy Council, as well as the Caribbean Court of Justice, the jurisdiction, what types of cases the Caribbean Court of Justice explores, as well as the arguments for and against. So as we continue this discussion, we welcome back again Queen's Counsel Leslie Thomas. How are you?
I'm very well. Thank you for having me back.
Thank you. So let's go right into the topic. I know last week we would have stopped at the commentary by a colleague who was for the Privy Council and drawing that example. But what I want to get from you is, are there concrete examples of cases where the CCJ and the Privy Council will have taken different approaches?
Yes, there are. As I said last week, the proof of the pudding's in the eating. So let's compare and contrast. For example, the human rights jurisprudence of the CCJ and the Privy Council, and let's see what conclusions we can reach. Indeed. And I think it's really interesting because there are two particular issues that really highlight how the CCJ and the Privy Council diverge in their approach. And you might be surprised in relation to, those differences. So the first thing that I would like to explore with you is the savings clauses. Now, I'll explain what a savings clause is.
Course, yes.
But you see, one of the biggest flaws in human rights protection in the Commonwealth Caribbean is the existence of saving clauses in the constitutions. Most Commonwealth Caribbean constitutions have saving clauses for existing laws. Now, what that means is these clauses, to a greater or lesser extent, immunize laws from constitutional challenge if those laws predate the Constitution itself. Now, if you think about that, the laws that predate many of the independent countries' constitutions are going to be those colonial laws from the United Kingdom, from England and Wales. So, of course, these clauses differ sometimes substantially from constitution to constitution. But the way that both the Privy Council and the CCJ approach these saving clauses is really interesting. Now, why is this important and why is this significant? Well, let's take something that's really significant and important and affects so a lot of the Caribbean countries, and in particular Trinidad and Tobago. That's the mandatory death penalty for murder. That, as you know, the Commonwealth Caribbean inherited from English law, the imposition of a mandatory death penalty in all cases of murder without regard to mitigating circumstances. Now, obviously, the Privy Council has done some good things in relation to this. It accepted in the case called Rays against the Queen in 2002 that the mandatory death penalty constituted inhuman and degraded punishment, since it had no regard for an offender's individual circumstances. But since then, it has become a major battleground as to whether the mandatory death penalty is protected by the savings clauses. And if I can just run through a couple of cases, yes. There's a case called Crown against Hughes in 2002, and another case, Fox against the Queen in 2002. And the Privy Council in both of those cases construed the saving clauses of both, respectively, the St. Lucia Constitution and the St. Kitts and Nevis Constitutions. And in both cases, the saving clauses were narrowly worded. It provided that nothing contained in or done under the authority of any law could be held to be inconsistent with the constitutional prohibition of inhuman or degrading treatment. right? So far, so good.
Yeah.
But in both cases, the Privy Council held that the saving clauses did not prevent them from holding that the relevant law was inconsistent with the Constitution insofar as it required, rather than merely authorised the judge to impose the death penalty. So, again, so far so good. Effectively, you have the Privy Council saying that these Caribbean countries could interpret these saving clauses restrictively, narrowly. But then came a case called Rondell against Trinidad and Tobago in 2003. And the issue in that case was the construction of another saving clause of the Trinidad and Tobago Constitution, which simply provided that an existing law could not be held to be inconsistent with or in contravention of fundamental rights. And it held that although the saving clause protected the existing law could be read with modifications so as to read the mandatory death penalty as a discretionary death penalty. So what was being argued in Rondell was that the saving clause should be read narrowly, and the Constitution should trump the saving clause so that judges didn't have to impose a mandatory death penalty. They could impose, they had a discretion to do so. And the Privy Council used this power to construe the mandatory death penalty as a discretionary penalty. So far, all good. So everybody's thinking, so what's wrong with the Privy Council? It's said that the death penalty judges have the right under the Constitution, reading saving clauses narrowly, and so they can. It's not mandatory; it can be imposed discretionary.
But that is something that was just decided recently in Trinidad and Tobago. Well,
all of this has been, it was overruled in a case called Boyce against the Queen in 2004. And there, less than a year later, the Privy Council overruled their own decision in Rondell, having convened a 9-member board panel for the Privy Council, the first time in 150 years. The Privy Council held by a majority that the saving clause in Barbados, which was of the same terms as that in Trinidad and Tobago, protected the mandatory death penalty from constitutional challenge. In other words, the Constitution couldn't trump the saving clause because the mandatory death penalty had been there before the Constitution. And the difficulty with that is that was, in my mind, a regressive interpretation of the saving clause by the Privy Council. And, the fact is that was regressive, as I say. However, what's interesting, that line of authority has been followed subsequently in a case called Watson against the Queen, and that's a Jamaican case. These saving clauses have been accepted to be of wider application, not just touching upon the mandatory death penalty. Some commentators have been absolutely scathing about the Privy Council's approach. In a study of LGBT equality in the Commonwealth Caribbean, some commentators have argued that the Privy Council's approach in Boyce, Matthews and Watson has become a significant barrier to equality. Now, let's contrast that, shall we, with the approach taken by the CCJ. Yes. The CCJ, in a case called Nervase against the Regina, and that's a 2018 case, overruled Boyce. So the CCJ overruled Boyce in respect of Barbados. In other words, and the court said, and this
overruled, and just one stick up in, they overruled Boyce that was decided in the Privy Council?
Yes.
Interesting.
Yes, because,
they have jurisdiction to do that?
Yeah, because Barbados has now adopted the CCJ as a final court of appeal, right? Yes. And so what the CCJ said when a similar issue came before them, they said that the proposition, and this is a quote, from the case, the proposition that judges in an independent Barbados should be forever prevented from determining whether the laws inherited from the colonial governments conflicted with the fundamental rights and provisions of the Constitution must be inconsistent with the concept of human equality which drove the march to independent status, end quote. Fantastic. In other words, you have the CCJ interpreting these saving clauses restrictively and saying that we can interpret these saving clauses narrowly and the constitutions can trump the saving clauses. And they also said this, quote, the general saving clause is an unacceptable diminution of the freedom of the newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the laws form part of inherited laws from the colonial regime must be condemned. Wow.
Yes.
That's powerful stuff. And the court also went on to point out, quote, the inescapable irony is that in most cases, the rules which it has been said that we are bound to apply here in the Caribbean have long since changed in England, while on the view that there has until now prevailed, we must remain trapped in the colonial past, end of quote. In other words, what the CCJ was saying is many of these rules, because as we know, the death penalty has been abolished in, well, it's still on the statute books, but it hasn't been implemented for over 50 years in the United Kingdom. Whereas, these saving clauses mean that the mandatory death penalty or life penalties have to be imposed in the Commonwealth Caribbean with no discretion. And the CCJ said this is not acceptable, that a restrictive interpretation of the general saving clauses should be adopted and the courts should use that approach.
But it's also about interpretation as well. The fact that the CCJ justices, they are in tune with what is maybe the culture or the norms or the customs in our society, just as how customs and norms prevailed decisions in the prehistoric Norman conquest era.
Yeah, absolutely. And remember, what we are looking at, we're looking at laws which were in place before most of our constitutions in the Caribbean. Ancient laws which have been long abolished in England. But here's the kicker. Very recently, this year, in the case of Chandler against Trinidad and Tobago, this was a few weeks ago, the Privy Council pushed back. In a 9-member judicial committee, the Privy Council, which could have followed the decision in Neves, decided not to follow Neves. And it reaffirmed that the mandatory death penalty in Trinidad and Tobago is saved by the saving clauses, reaffirming the correctness of its decision in the case of Matthews. And here's the thing, the Privy Council acknowledged in its closing paragraphs of its decision that the mandatory death penalty is recognised internationally as cruel and unusual punishment. But in the board's words, it will often be disproportionate and unjust, but on the basis of the board's, that's the Privy Council's construction of the saving clause, it was constitutional. Completely at odds with the decision and the approach taken by the CCJ in the Neves case. Now, before I had done my research, I wouldn't have thought there would have been that much of a difference between the CCJ and the Privy Council in terms of the interpretation. But that, you can see that the CCJ is taking a much more progressive approach to the interpretation of these laws than the Privy Council. There's a real difference also in the rhetorical style of Nervais with the CCJ and Chandler with the Privy Council. I say Nervais is an eloquent, discussion to high constitutional principle, whereas the Privy Council's approach in Chandler has been cautious, conservative, and deferential to precedents. That's not to say that Chandler is devoid of principle, but on the contrary, the board, the Privy Council appears to place greater emphasis on the principle of legal certainty, citing legal philosopher Lon Fuller, whereas you can see the two very different philosophies of the CCJ and the Privy Council about how a democratic society should function clash. So what can you draw from that? Well, I think you can draw this. I think the Privy Council and CCJ have diverged so much from each other on a fundamental issue of constitutional interpretation, which cuts to the very heart of constitutional jurisprudence. More than that, they have a diverge in their general approach to constitutional law. And so that's the saving clauses. And if you thought, Rondell, that it stopped there, it doesn't, because the second issue, if I can deal with very, very quickly, is the nature of preambles in constitutions. You're probably thinking, what's a preamble in a constitution? Well, let me explain it. In most constitutions, in the Caribbean and elsewhere, at the start of the Constitution, at the start of the Bill of Rights, there's a broad statement of principle, such as life, liberty, security of the person, and the protection of the law. That's a preamble. And they go on to, then the Constitution will go on to state or set out specific rights protected by the Constitution in subsequent clauses. Now, a very controversial issue for decades has been whether these initial provisions are merely preambles or whether they create separate enforceable rights. Now, the Privy Council has tended to take a narrow textual approach to this question. And we can see this in a case in 1967, a Maltese case called Oliver against Buttigieg. In that case, the Privy Council held that the relevant provisions of the Constitution of Malta was merely a preamble and did not create separate enforceable rights. And in reaching that conclusion, Lord Morris placed greater emphasis on the fact that the provision began with the words "whereas," and he said that provision was an introduction to, in the sense of a prefatory or explanatory note in regarding the sections which were to follow. And then there's a Mauritanian case of Society United Docs against the government of Mauritius in 1985, and again, the Privy Council reached an opposite conclusion, but in respect of an equivalent clause in the Mauritanian constitution, holding that it did create enforceable rights. But the reason for the distinction was that the Mauritanian provision was worded differently, whereas the Maltese constitution began with "whereas," the Mauritanian provision began with "it is hereby recognised and declared that." I'm not sure, when you look at the substance of that, whether that difference is one that stands up to scrutiny.
It's one of the same, I should say.
Many people would see it as one of the same. Here's the thing. So the Privy Council has placed weight on this, and again, there's a lot of Privy Council jurisprudence saying that these preambles, if they use the word "whereas," are to be treated very narrowly as not providing recognisable or enforceable rights. Now, here's the thing. The CCJ, by contrast, in recent years, has taken a broader much less black letter view of the issue. And in a landmark case of Maya Leaders Alliance against the Attorney General of Belize, which was looking at the equivalent provision in the Belize Constitution, Section 3, it held that this was not a mere preamble or introduction, but conferred substantial land rights for the indigenous Maya people in Belize. And it held that the Maya could rely on what was considered to be a preamble, protection from arbitrary deprivation of property, and that right was held to be broader than the protection from compulsory acquisition of property conferred by a different section in the Constitution. Thus, there could be reliance on this preamble by the Maya people. And here's the thing, the CCJ analysed the same issue more closely in the mandatory death penalty cases of Neves, which I discussed just a moment ago, yes, and held that Section 11 of the Constitution of Barbados contained or conferred separately enforceable rights, notwithstanding it began with the word whereas. In other words, it comprehensively demolished the reasoning adopted by the Privy Council in the case of Oliver, in the Oliver line of authority, first noting that the Privy Council's reasoning attributed an unusual reading of the word preamble. The Constitution of Barbados did have a preamble, but Section 11 was not part of the preamble. It was a substantive portion of the Constitution. And it held that language of Section 11 was not aspirational, but it was a preliminary statement of the reasons which made the Constitution or sections of it desirable. And they gave, the CCJ gave short shrift to the line of reasoning of the Privy Council in Oliver and Society United Docs, holding, quote, that when one reviews the two sections of the Maltese and Mauritius constitutions, did they really intend to impute such different meanings as being attributed to them? It would seem to us that the Maltese constitution, the word whereas, could easily have been construed as meaning it is hereby recognised and declared that, or even simply in the light of the fact that. These are meanings normally attributed to the word whereas. In other words, the CCJ held that Section 11 was not a preamble, but gave rise to fundamental rights which could be protected by law. Once again, therefore, we can see the CCJ in recent jurisprudence has taken a broader, more progressive approach to constitutional rights in the Privy Council, and the distinction drawn by the Privy Council between the precise wordings in these cases on the preambles was technical to the point of absurdity. And so for those reasons, I conclude that, the CCJ has demonstrated not only independence in thinking, because remember, Rondell, yes, these were cases brought by governments of these independent states. And so, you had individuals who were challenging governments, and the CCJ made it clear that it was prepared to go against what the governments were arguing. Yeah. And that comes back to what I was saying last week, that, if you ever wanted evidence that the CCJ and its judges were independent-minded, you have these cases which demonstrate it.
And particularly, the argument that I did state verbatim with respect to Trinidad and Tobago and judges being made to resign, etc. The government of Trinidad and Tobago will not have any jurisdiction over a judge at the CCJ. In terms of whether or not they can resign, whether or not they have any influence. That influence is totally independent, or not even independent. Yes, it's independent, but there should be no country or governmental influence on these judges.
Yeah, and as I say, when you look at the decisions that have been made, the CCJ has shown itself capable, more so in a way than the Privy Council, that it's prepared to uphold these fundamental constitutional rights in a way that the Privy Council has fallen short of.
Do you think that the Privy Council has been viewing such cases in black and white because they have no interest, or rather, not really no interest, but they just see things before them? They don't understand the culture, they don't understand the society, they don't understand the historical context of how laws were created by the colonies, by the colonial masters, and how it should be in line with what it is today.
Well, the irony is, I don't think they are, because in fact, the Privy Council has accepted in many of these cases that the saving clauses which seek to uphold these ancient and archaic and quite frankly ludicrous laws there's an acknowledgement that they're ludicrous, but they've stuck to the black letter meaning of the law, that these laws were around before. Constitution has saving clauses, and these laws are saved by the saving clauses. Now, why might the Privy Council do that? Can I hazard a guess? This is purely a guess on my part. You will note, and that in the early 2000s, there was a string of cases. In the late 90s, early 2000s, there was a string of cases, particularly coming out of Trinidad, about the death penalty. People being on death row for more than 5 years, and there was uproar because of this, because it was popular, because of the high crime rate at the time in Trinidad and Tobago. That it was a popular view, and politicians could run on the view that yes, if people commit murder, they should die, they should hang. Yeah, that was quite a populist view. And so when the Privy Council, in those early cases, challenged and undid some of that thinking and that decision, there was a lot of uproar across the Caribbean about, why should the Privy Council come in and interfere with, what's going on locally?
Yes.
I think, and this is the guess, and this is the potential influence, ironically, influence on the Privy Council as opposed to influence on CCJ. I wonder if the Privy Council, because the voices were quite loud then, thought about whether or not it should be coming out with decisions which were seen as unpopular to governments, particularly in relation to the death penalty, which is why we had this reversal within a couple of years, and the Privy Council taking a very different approach to the approach that it had been taken, because it potentially thought its position was under threat. Mm-hmm. So, so what I've done, I don't know if there's any truth in that, but I put that out as a theory. But what I've done is I've turned the whole argument on its head, in the sense that, ironically, the pressure and public opinion appears to have influenced the Privy Council in its decisions on some of these big constitutional cases, more so than it has affected the CCJ, which is ironic in the extreme.
Indeed, just as how you have theory, that's the same way you have that theory, other persons have that theory about CCJ, but it can never be tested unless you try at the end of the day. Absolutely, and that's why, as opposed to just having theories, I don't know if the theory I propose is right or wrong, probably wrong, but it's interesting. That's why it's much better to look at and see what the court is actually doing. Let's not rely on theory. Let's not rely on speculation or on myth or folktale. Look at the evidence, and the evidence is there with our own eyes. Indeed,
and the CCJ, on the face of it, is given decisions just as good, just as equal as the justices in the Privy Council.
Professor, we are out of time, but your closing comments on this topic.
Thank you. I would like to say this in terms of closing comment. I just think the CCJ needs to be given a fair chance. I would encourage those in the regions to look again, and also governments not to be so partisan, and oppositions not to be so partisan and tribal in relation to the adopted. Look at the evidence. The evidence is what matters.
Indeed. Professor, thank you so much for gracing us with your expertise. Of course, guys, we will be repeating this episode, the two-part series. So thank you so much, Professor Leslie Thomas, Queen's Counsel of Garden Court Chambers, JC Legal Solutions, as well as Professor Law at Gresham College, United Kingdom. Thank you so much, sir.
Thank you.
So guys, it's a wrap. This is the end of the two-part series. Thank you so much. You have been watching Strictly Legal with Rondell Donawa, speaking about the CCJ being adopted as the Commonwealth Caribbean Final Court of Appeal, as well as in Trinidad and Tobago. You have been watching Professor Leslie Thomas, Queen's Counsel from United Kingdom. So thank you once again. See you another time with another new episode. God bless. Be safe.